27 questions. The first one is, in the cheat sheet entitled Preventing Crime and Limiting Liability for Community Associations, it suggests, and this is a cheat sheet that our firm, creates, it's on our website. It suggests that the association review local state laws and local ordinances to know what security measures are required. What state laws and ordinances were you referring to? Well, what I would recommend to you, I don't have that cheat sheet right in front of me, but what I would recommend to you is sometimes cities, towns, municipalities may have some ordinances that may affect your association. I'm trying to think of some good examples. Well, maybe if you have a gate, a controlled access gate for your community, there may be some special requirements to get a permit for it. And there's a reason for that, because if there's some sort of an emergency vehicle that's trying to get in, they have to have the box that automatically opens up the gate. I think would be one that comes to mind. I think as you look at the different things that you're trying to implement in your community, are there any state laws that may prohibit you from doing that? Like maybe installing cameras or videotaping and keeping the tapes. All of these things are things that should just be considered and discussed. Make sure that anything that you're implementing to keep your community safe isn't violating state law or any ordinances. Okay, next question, number 2. Can a person waive their attorney-client privilege to speak to the without getting into trouble? But so let's say that you're hiring an attorney and you've had private conversations with that attorney. And basically, if you waive the attorney-client privilege, you're allowing the attorney to talk about that issue, or you can talk about that issue. So it's ultimately up to you whether or not you want to keep that information confidential, or if you want it, to be broadcast to third parties. And can it get you in trouble or not? Ask your attorney. Be careful, because you hire your attorney to give you advice, and in my opinion, those communications should be confidential. Okay, next question, number 3. Our homeowners amended our CC&Rs to lower the percent of votes needed to amend the CC&Rs from 67% to a simple majority. Is there any Arizona statute that requires a certain percent of homeowner votes to amend the CC&Rs? Okay, so great question. So really only for the Condominium Act is there a law that says that you can't go below 67% if you're a condominium. If you're a planned community, you can go with that simple majority. That's perfectly legal under the Planned Communities Act. Question 4. What risks are faced by a neighborhood association that houses a residential care facility that may or may not have residents that are in an FHA protected class and are not licensed? Okay, this question raises fair housing issues, and we have a great cheat sheet on the Fair Housing Act that is called Federal Laws. You can find that on our webpage at mulcahylawfirm.com on our cheat sheets. So basically, there's a lot of confusion about the Fair Housing Act and whether owners who live, typically we see this in a planned community. So let's say an owner owns a home in a planned community and they decide they're going to lease it to a care facility. So, maybe a group home for the elderly or a group home for the disabled. And so if that's going to happen, whoever's leasing that property and going to be creating this group home, under the Fair Housing Act, the association has to make a reasonable accommodation for them, even though they're running a business, and your documents may not allow businesses to be run. Your CC&Rs may not allow businesses to be run in your association, and this clearly is a business, right? But there's an exception under the Fair Housing Act that we have to allow this, and we have to make a reasonable accommodation for it. And so, how this typically will work is the association will find out that, hey, somebody intends to do this, or they're already running the group home. What I would recommend is that you reach out to the owner and ask for more information about the group home, like what type of group home is this? Or maybe they come to you and they're giving you the information up front. You want to check with your attorney to make sure that the type of group home that they're planning to have there is going to be something that we are required to let them do. Group homes for the elderly, group homes for the disabled, group homes for like recovering addicts, all of those are allowable under the Fair Housing Act. But like a group home for, like troubled teens, that may not be something that's allowed under the Fair Housing Act. They'd have to find out more information about it from the owner. And so the question is, what risks are faced by a neighborhood? Well, I mean, of course, there's going to be people that are going to be upset that there's a group home operating in your neighborhood. My experience with group homes has been that there's a lot of fuss before they go in, and the residents come to the group home and live there, but usually they turn out to be great neighbors. Like there aren't any problems. I can think of a handful of problems in 28 years where maybe the residents were causing an issue. Usually people are inside all the time and they don't get a lot of visitors, and they pay on time. So it's usually not something that you can even determine that there's a group home there. On the times where we have had an issue, it was typically where it was like a group home for recovering addicts, and somebody got out and maybe got off the wagon. And that could have been an issue, that there was an issue with that in the community. Basically but that's few and far between. So are there risks? I don't typically see them, but you want to go over the risks with the owner, and the owner needs to go over them then with the landlord to make sure that, if it's like a dementia care home, that there's adequate things in place that, these people can't just walk out of the house and get lost, or, fall into the pool by mistake or something like that. And these are just all good things that you can talk about with the owner, to make sure that they're complying, with all safety requirements that they have. And also they do need to be licensed, and they need to be registered with the city, town, and municipality that the property is located in. So typically, if they aren't licensed, of course you can go to your city, town, and municipality and make a complaint. Okay, let's go on to question 5. Is there any movement by insurance companies to push HOAs in Arizona to have a fully funded reserve account like in Florida? No, not by insurance companies typically. It's going to be more like by the financing companies like Fannie Mae and Freddie Mac, who are writing loans. They'll ask for information from the association, in terms of how much, how many people live off site, or how many properties are rented, how much money do you have in your reserve account? And if it's low, they may not give the loan to the owner because they can foreshadow or foresee that no money in the reserve account means special assessments. And if there's a big special assessment, the owner may not be able to pay it. And then they might lose their property because they don't pay the mortgage or the deed of trust. So I haven't seen any movement by insurance companies for fully funded reserve account. Doesn't mean it can't happen, especially with the insurance difficulties right now. But we do see it from lending companies. And I think that there, we don't have a law that says we have to have a reserve account or that we have to have a reserve study. But we do have a law in Arizona that says that if we have reserve account or reserve study, we have to disclose it to a buyer before they buy their property so that the buyer can be fully informed about, the status of the association. So I think we're moving in that direction where, there might be some sort of a mandate for a reserve fund and reserve study, but we're not there yet. And I haven't seen any bills on that in the past 5 years. So it's kind of stagnant right now. Okay, question number 6. In common area buildings, which dogs are not permitted? Do support dogs have the same allowances as service dogs and must be permitted? Okay, this is a really good question. So let's give an example. Let's say you have a clubhouse in your association, and you have a rule that says no dogs in the clubhouse. And we know, of course, that service dogs under the Fair Housing Act, like a trained service dog for somebody who is blind or who has epilepsy or who has hearing issues, all of those dogs are going to be allowed under the Fair Housing Act into your clubhouse. What do we do about service animals, like an emotional support pet? Do we have to allow those into the common areas? It's difficult on emotional support pets because they really sometimes don't have any formal training. Like most of the time, they are just pets that, you can get a certificate by going somewhere online and having a quick interview with the counselor. And then next thing you know, you've got a certificate saying that your dog's an emotional support pet. It's quite different than, the service dogs where, the dog is with the person at all times. They're not on a leash, and it's very apparent that this person needs a service dog. I think associations handle this differently. Every association handles this differently. In my experience, most do not allow an emotional support pet, like inside a common area, clubhouse. But of course, they do allow a service animal. Some do allow emotional support pets in addition to service animals. I mean, just remember service animals that are emotional support pets, emotional support pet animals may not have any formal training, so they may misbehave when they go in the clubhouse or go into the pool area. So I think you have to just kind of look at this on a case-by-case basis and decide what's best for your community. If you have a dog that is a service animal, we never ever had a service animal misbehave, but if it's an emotional support pet and it's misbehaving in these areas and you've been lenient on it because they've provided you with the paperwork that's emotional support pet, you may have good reason to say, hey, you can't bring the dog in anymore to the clubhouse, unless it's leashed or unless it's, you just can't bring it in anymore because it, isn't able to, behave well in an inside area. So, okay. Let's see. So from a legal perspective, I believe that you can withhold the emotional support pet from going into the common areas, but obviously we can't withhold the service animal from doing that with their owner. Okay, next question, number 7. There were lots of open meeting questions at the December 1st Friday. I want to make sure I heard you correctly. Executive sessions require notification and agenda 48 hours before, even if nothing is voted on, such as an orientation or a workshop. That's correct. So anytime a quorum of the board is meeting to discuss business, whether it's an open session or an executive session, we have to give notice 48 hours in advance of the meeting, and we also have to provide an agenda about the topics that are going to be discussed at either the open session or the executive session. And even if nothing is voted on, that's right, you still have to make it an open meeting. So anytime the board is present discussing association business, a quorum of the board present, it needs to be an open meeting. Whether you're voting on things, whether you're discussing things, it needs to be an open meeting. Okay, question number 8. How does Kalway versus Calabria Ranch HOA affect associations attempting to amend CC&Rs? Our board received an unsolicited legal opinion that Kalway ruling now prevents HOAs from amending CC&R provisions that people would not have reasonably suspected to be subject to change. As such, they say any amendment can be expected to result in a legal challenge and thus should not be attempted. Okay, so we have a great blog on this Kalway versus Calabria Ranch case that I would encourage you to take a look at. It is posted on our website at mulcahylawfirm.com, and it can give you more of a deep dive. So bottom line on the Kalway case, it was decided several years ago by Arizona Appellate Court, and it does make it more difficult for associations to amend their CC&Rs, no question about it. CC&R amendments must be reasonable, and they must be foreseeable. And so you said, owners would have to, foresee that this section would be amended. And, it's in some situations, it is, limiting our clients to be able to amend their CC&Rs. What I would recommend is talk to your attorney or talk to our law firm about what are you proposing to amend in the CC&Rs. I mean, this is not like a bright line rule that says you can never amend your CC&Rs again because of Kalway versus Calabria Ranch, which it sounds to me like, but that's what whoever gave you this unsolicited opinion said. That's not the case. The case here is that you have to be strategic in terms of how you prepare the amendment. And you may need to grandfather current owners. You may not be able to do certain amendments right now because they're not foreseeable. But we're still doing a lot of amendments for clients, but we are being strategic on them, and we haven't gotten any of these amendments that we've done have not been challenged by owners under Calabria. Kalway versus Calabria Ranch case. And so there's a way to still do amendments that are, reasonable and that are foreseeable that this section could have been amended. So reach out to our firm or talk to different legal counsel than the one that gave you the opinion, because amendments are still being done. It's just you need to be strategic on how you do them. And there are some subjects that we just won't do the amendment. I'll tell the client, like, hey, I don't think timing is right on this based upon the Kalway case. I think this could be challenged, especially as I hear more about your association. Some associations, a controversial amendment is going to be challenged. And if it's not foreseeable, I probably wouldn't do it right now in light of Kalway. There's a bunch of cases right now that are currently pending in the Court of Appeals in Arizona that may change the Kalway case, may change the ruling in the Kalway case. So that may not be the case that's, the case that we're citing next year. There might be a case that makes it a little more lenient to do amendments. Okay, question number 9. Our board really needs to have a working meeting where we can just have a discussion to set priorities for the year and get a good inventory of the state of our community. We are not trying to be non-transparent, but we just need an opportunity to have a deep discussion. How can we do this? Board only without violating the open meeting law. It wouldn't conform to the rules of executive session. Could this just be an organizational meeting? Okay, the best way to do this would be to have less than a quorum of the board meeting. So you may have to meet with a couple different groups of your board, but it has to be less than a quorum, because if you have a quorum of the board meeting for a working meeting discussing association business, it would be an open meeting. It would need to be an open meeting under the law. So workaround on that is meet with people individually. The board president can meet with people individually or meet with a less than a quorum to not violate the open meeting law. Okay, question 10. Pickleball is becoming quite popular and requests are coming in for approval. Does the HOA have a reasonable obligation to notify nearby homeowners upon discovery or when approving submittals for backyard pickleball courts, particularly when two lots will be located close to each other within a small community? There is no mention of pickleball courts in the documents. Can affected homeowner file a lawsuit against the association? So Google pickleball HOA Arizona, and I think you'll see a bunch of cases. I know, and I read articles about owners in Paradise Valley that have put in pickleball courts, and then the neighbors aren't happy about it. I think you have to look at this on a case-by-case basis. Like, okay, how large are your lots? Number one, how far apart are the lots from each other? Is this the type of change allowed? Can the architectural committee approve this type of change? And I definitely do think that there should be some consideration of how this noise will affect the neighbors and some discussion with the neighbors, because what happens is somebody puts in a pickleball court and then it drives the neighbors crazy. They've got lights, they're playing at 10 o'clock at night. And I play pickleball and tennis, so I know it is kind of addictive. And it's fun and it's loud, much louder than tennis. Not just the ball, but it's, it's a little bit more energetic game than tennis. And so people are laughing and screaming and yelling, and it's definitely a louder sport than tennis. So to be careful on this, I would recommend that you talk with your attorney, look at the documents for your association to determine if there's anything in there that would or would not allow us to have an owner put in a pickleball court. Very seriously consider getting approval from the neighbors on this. And if the neighbor doesn't approve it, maybe do some sort of a noise determination to see if the pickleball noise would have a negative impact on the properties that are adjacent that might be, not wanting this. And there's also all kinds of things that you can do. There's these new pickleball walls that you can put around the pickleball court to minimize the noise. And there's also some pickleball balls that you can use that are less noisy. The wall thing is expensive. I know I've played at a court that has those, and it does limit the sound that's coming out of the wall, but sound travels up, and so it still comes up. You can still hear it. It's not like a total, sound barrier. So lots of things to think about on that. And if you have questions on it, please reach out to me and I'd be happy to look at it with you a little more carefully so that you don't get sued for creating a nuisance. Okay, question 11. Can a citizen of Maricopa County request to speak at a legislative committee meeting? Great question. I believe that you can. What I would do is reach out to the state legislature in Arizona and, find out from them what type of committee hearings you would be allowed to attend, and whether or not you can make a statement. Now, everything's kind of virtual now since the pandemic. So a lot of these committees are virtual and you make comments, you submit comments virtually, I think in advance of the hearing, and then the committee members can read them in advance of the hearing, or after the hearing, you can contact the committee members. So I think that the game's kind of changed since the pandemic. So depending on what issue you have and what committee you want to attend, it may need to be like a written statement that they read, and you likely aren't physically going down there again and waiting in line to talk like it used to be pre-pandemic. Okay, question number 12. An owner is concerned that they are unable to enjoy their back patio because their roofmate smokes a lot on their screened-in porch. Does the non-smoking neighbor have any recourse? So we get this question actually kind of a lot. So what I would recommend at first would be for the neighbor just to notify the other neighbor that this is affecting them and see if they'll voluntarily, stop doing it. If they don't stop doing it, then you probably need to escalate it to the association and write a letter to the association, ask them to be involved. If that happens, the association typically sends a letter to the neighbor that's smoking saying that, hey, we received a complaint about this and, this is a nuisance, please stop doing it. So I would definitely reach out to advise the owner to try to resolve it amicably. If they can't, then the association should get involved. Typically, this will be escalated to the association's attorney to help you legally resolve the matter with the owner. Okay, question number 13. Can the board request all records from our property management company, physical and digital? We are selecting our 2025 property management company and would like to get the archives prior to giving notice to the current company. Ooh. Well, here's what I can tell you is that if you do that, well, first look at the contract, because the contract that you sign with that management company likely talks about the records and how they're, maintained and what happens at the time of termination. I mean, I don't know how old your association is, but I mean, the history of the association is typically going to be a lot of boxes if you don't have them digital. And if it is digital, maybe you can just get a code to get in. If you're a board member, I mean, you should be able to have access to all your documents if they're digitalized. But, making a request to see that all physical and digital records, they're going to charge you, I bet, just like they would charge an owner 15 cents per page. And that's not going to be, something that's going to be a good thing. I think kind of what the underlying question is here is, I think the management company, right? That's what I'm hearing. And your word's going to destroy your records when you terminate them. So I think the best advice I can give you is look at the contract, figure out what the contract says about the documents, how they're maintained, what happens when there's a termination, and reach out to our firm or another lawyer that represents associations and, talk about a strategy on this, because some management companies, unfortunately, do have a reputation of doing things like this in transition, like associations have problems getting their records, and getting advice from the attorney, getting their opinion on that management company off the record, and what's the deal with them on this, I think is the way to go. Okay, question number 14. Can a homeowner serve on a compliance committee since compliance violations are sent to specific homeowners and protected under the open meeting exception? So it just would depend on what your documents say. Like, I don't know how the compliance committee is set up. Is it the board runs it, or is it like a separate committee run by homeowners? I would think that would be kind of odd. Typically, the board handles compliance issues. In some cases, the architectural committee handles compliance issues. So having a compliance committee run by homeowners might be, it's unusual. Usually the board's doing that. So I don't know what your documents say, so it's kind of hard for me to answer that question. Okay, 15, do you recommend boards prepare and pass a motion requiring board members to comply with the CTA? I think that's a good idea, especially if you have somebody that is unwilling to do it, just having a paper trail so that if, there's penalties or whatever, if you don't comply with it after the stay is potentially lifted in the Supreme Court case, that way, you can have a vote saying that, okay, we're, we're, we're having a vote because we think it's necessary to comply with the Corporate Transparency Act. And anyone who doesn't comply, it's basically at their own risk because there are very stiff penalties if you don't comply with this, if that stay gets removed. So I think it can't hurt to do that. So I think that's a good idea. Okay, question 16. But most associations don't have to do that. I just like to say that because most associations are just compliant with this and it's not a big deal. Okay, question 16. Can an association charge a check processing fee for payments made by check if another form of payment is offered for free to homeowners? Our association is self-managed for 156 units, have online meetings, online communications, online newspaper, online calendar of events, and a homeowner online portal for all documentation, meeting minutes, financials, ACH bank payments are free. Okay, so you're wondering, can we charge a check processing fee if someone makes a payment that's not electronic? I honestly, unless it's in your CC&Rs, I wouldn't do that. And giving you the authority to do that, I wouldn't do that. Just, people unfortunately aren't sometimes technologically advanced. And, you can lead them to the water, but they may still want to write their check. And unless it's in the CC&Rs that we can charge an additional fee for doing this, I think you're going to be hard pressed doing that. I mean, you can try, but if the homeowner pushes back on it, I wouldn't push it. Okay, next question, 17. Our CC&Rs under property rights do not have a provision of notice that limits homeowners' guests to any amount. Since there's no provision, that means to me that the HOA cannot create a policy limiting how many grandchildren I can have play on courts. Can you comment? Well, typically that's something that's going to be put in the CC&R, not in the CC&Rs, but in the rules. And so the CC&Rs typically don't ever have a provision that says like you can only have 14 guests at the pool or 10 guests at the pool or something like that. That's typically something we see in the rules. So if it's in your rules, I do think that would be enforceable. I don't know how many grandchildren you have, but, as long as it's a reasonable number and, they're just coming, to visit you occasionally and, I don't really see what the big deal is here. But if it's like 20 people and you're coming every Sunday and running a tennis lesson or something, that might be something where a rule could prohibit you from doing that. Okay, question 18. It is well known that our board of 5 frequently meets with 3 as they will vote in president's favor and 2 are left out and not notified at the meeting. Is there a regulation preventing that? Also, the community is never notified. There are executive meetings, which are not emergent and yet happening, which are not emergencies and yet happening at the will of the president. How do we work with this? Okay, I don't know if you're a homeowner or a board member. I'm kind of thinking that you maybe either know the 2 people that are being left out on the board of these meetings, or maybe you're one of them, or maybe you're just a homeowner. So I think what you need to do is remind the board in writing that this is the law. Anytime a quorum of the board meets to discuss association business, it needs to be an open meeting. I want to share with them my cheat sheet on open meeting law and board meetings. We have 2 different cheat sheets on this. If they continue to do this, you certainly have rights. So you're going to write the letter, giving them the information on this. And then if they continue to do it, you have rights. You can hire an attorney to write them a letter on your behalf, telling them that they're violating the open meeting law and that you're going to sue them. You can actually file a lawsuit. You can go to the Arizona Department of Real Estate and, have an administrative law judge hear the issue here, and that they're not noticing their executive session meetings, that they're not noticing meetings where they have a quorum of the board discussing association business. You could file a complaint with the ADRE, like I said, and have an admin law judge review it. You can run for the board yourself to try to make positive change if you're not on the board already. You can remove the board by following state law. And there's a lot of different options you have to get them to comply. Okay, question 19. Can the street parking vote occur via services like HOA Vote Now, or does the vote have to be in person after an in-person quorum is met? Great question. You can do online voting for this, yes, but you have to do it in conjunction, with a meeting. But HOA Vote now does, online voting in conjunction with meetings all the time. You do have to let people that attend the meeting in person vote at the meeting if they so choose. So that's HOA Vote Now does that already. They try to get as many people to vote electronically, but if somebody comes to the meeting, they certainly have the right to vote in person. Okay, question 20. In our second-story condos, the smell of legal recreational drugs used on the first floor rise when the HVAC is on, apparently pulling airflow from ? Under the baseboards, we're not sure. This appears to be an issue occurring systematically beyond the walls in individual condo owner space. Does the association contract ceiling condos or individual owners? These units were built in 1998. Okay, so I think I would start with trying to figure out who is smoking the, recreational drugs, and whoever's getting the smell in their unit, just like the porch screened-in porch example with the smoking. You should reach out to the person that you think is smoking and tell them it's bothering you, and ask them not to smoke in that area because it's coming through the vents or whatever. If they continue to do it or it continues to be a problem, then go to the association. The association should write them a letter too. Because you're a condo, there may be an obligation for the association to become involved. And maybe we have to tell the recreational smoker that they have to have a special purifier in their unit. I mean, there's lots of different solutions that we can come up with to make sure that it doesn't bother the other units. But typically the lawyer does get involved, and we've handled a bunch of those cases before successfully. Okay, question 21 from one of my favorite managers. Good to see you here today. Is it okay for a board member to go door to door to discuss the pending vote for the on-street parking rule when they openly state to the homeowner that they are against it? I think it is okay. People have a right to, lobby one way or another. So I don't think that there's anything illegal about it. This person's a homeowner and they have a right to do that. I mean, obviously we should be telling them that they should be introducing themselves as a homeowner and that they're not officially acting on behalf of the board or anything like that if they're going door to door. Question 22, our HOA fees are presently $437 monthly. The management company is suggesting increasing to $545 monthly. Is there a maximum percentage that the fee can increase yearly? So I'd have to see your association's documents. Your CC&R should specify how much they can be raised without a vote of the membership. There is a state law in the Planned Communities Act that talks about if your documents are silent on how high you can raise the assessment rate, or if the increase that's allowable is more than 20%, the state law will kick in, and in those circumstances, you can only increase it 20% higher than the previous year's assessment. Anything, over that would require a vote of the membership, a majority of the members. Okay, question 23. We are a small association with 14 duplex units, 28 units total. What is the ballpark cost of a reserve study? I mean, I don't know how many amenities you have. I'm guessing not that many. So I would guess somewhere between like 500 and 1,000. Would be my range. Okay, 24. In a condo, what should the insurance and installation requirements be for installation of an EV charger? Well, I think that a couple of things. So the type of insurance, I would require that they notify their insurance company in writing that they're planning to do this. We may also need to notify our insurance company, the associations, if it's on the common areas, which it probably is either on a limited common area or a common area, to find out if there are any, special requirements that they may have. Question 27, EV charging stations inside the garage of a townhouse or condo. Can the association require registry of this and/or require additional insurance in the event of fire or damage? Unless it's in your CC&Rs, you probably can't require that. Okay, 26. I'm assuming that Okay, so if it's planned community, no. If it's townhouse, it depends on if it's legally treated as a condo or a planned community. If it's a planned community, like it's a garage that we can't see inside, we don't know what's going on in there, and it's not a limited common element, probably we can't. In a condo, we'll go with the same analysis that I did on the prior question. Contact the insurance company. And yes, in a condo, if they're putting it on common areas or limited common areas, of course, they have to ask for permission. And I think we should check with their insurance company and our insurance company for the association to see what their position is on having that in the area that it's proposed to be, installed. Question 26, how much does it cost when going into a receivership? We have a resident who want this to happen. I need an idea of cost. Okay. So I haven't had a receivership recently, but meaning in the past 5 years since COVID. But prior to COVID, we were seeing, first there's a cost for whoever's filing the lawsuit to get the receivership. That's probably going to cost about $5,000 in legal fees. And then there will be a cost to pay the receiver. And it depends on how long the receiver's taking care of business at your association. If it's a year, I think you could kind of expect about an $80,000 salary for the receiver. And I don't know how many unit owners you have, how much that will cost per person. But remember, the receiver, I don't know why people would want this to happen. The only time I can see them wanting this to happen is if the board is totally out of control and they can't effectively run the association. We just need somebody to come in and stabilize it. But that's kind of an approximate cost. Sometimes, if it's a very small association, maybe half of that cost. It really, we're at the mercy of whatever receiver the judge decides to hire. Okay, 27. Let's see how many total questions. We had the opposite problem this year when looking for new board members. The problem was that the president stopped accepting requests to be on the board as of October 31st. Therefore, 3 people were not able to run. By doing this, the president guaranteed that he would get another term on the board. Do you think this was fair? I would think that people could be added to the ballot until they were sent out. Well, if there was a deadline that was in writing for your association, that October 31st was the deadline, and, they didn't comply with that, then I'm sorry, they probably did lose their right to run for the board this year. If there was no deadline, it was just some arbitrary deadline that the president put in place, that's probably not a good thing and could be challenged. You also have to check to see if anybody can be added to the ballot as a nominated from the floor or a write-in candidate. You'd have to check your documents to see if that's allowed or not allowed, because they might be able to run that way, although it's a lot harder to run that way because all those ballots that were mailed out, they won't have their name on it. Okay, question 28. Can neighbors smoking marijuana at all hours of the day and night be considered a nuisance? So we've kind of had 3 questions on smoking today. Yes, if it is disturbing, 1 or more residents, it could be considered a nuisance, and the association may have to get involved in that. Question number 29, can a gated HOA prevent a homeowner's realtor from placing a note or card at the gate asking that they call the agent for a code to get in? I do think that you could do that. I don't know the circumstances on this. Maybe what I would recommend would be that the association's management company or the president reach out to the realtor and find out what's going on. Like, we don't want people unaccompanied coming into the association. And so, I don't like the idea of the card being taped, because anybody could just call the realtor and say they're coming in, and, they could come in, cause somebody's home to be robbed or whatever, casing the neighborhood. So I think that is very okay for you to say, hey, we don't want you doing this, and can we open the lines of communication as to what you're trying to accomplish here? Okay, question 30. Our property management has decided to do online voting on the parking issue. How can I ensure that I can verify the votes were voted for or against, as I've gotten feedback from property manager that they favor it? It has not been enforced, but we have a new zealous property management company. Okay, so you should be able to see all the votes by making a records request to the management company after the election. You can't see them before the election because they won't be tabulated until the actual night of the election, or the day of the election, or the day of the vote on this, not election. Okay, question 31. We self-manage our neighborhood of 50 homes. We have a homeowner who has been provided with answers, but continues to ask the same questions and emailing 5 to 10 times a week. Ooh, this is your gadfly. Sorry you have that. He is passive aggressive in emails and sends misinformation to all neighbors in the community. He wants a private meeting and wants answers again, but will only say he is correct, even with proof. Emails are sent to the president who doesn't know what to do anymore. How much time is required to answer a person like this, as it is exhausting? He is a bit unstable, stating he's a veteran and he feels discriminated against. Okay, the best piece of advice I can give you right here is take a look at our cheat sheet called Dealing with Difficult People, Harassment and Dealing with Difficult People. It's on our website at mulcahylawfirm.com. Best advice I can give you here is have your board hire our firm and have us deal with this owner going forward. We will write them a letter saying do not contact board members, anymore regarding any issue pertaining to the association. You can still make your assessment payments the way you normally do, but do not email board members, do not contact them directly. Of course, this person can still go to the board meetings, but they shouldn't be allowed to hijack the board meetings. And if you consult with our firm on this, what we will do is we'll send them a letter saying, stop doing this, stop contacting the board members, all communications with us in writing by U.S. mail. And we're very effective. This strategy works very well. We've used it thousands of times over the past 28 years, and it's been successful. So reach out to us. We can make your life a lot easier by handling it that way. Okay, question 32. Are meetings to discuss architectural review committee requests allowed to be done via email? And do architectural committee request reviews require notification to the community? ARC reviews are presently performed via email. There's no meeting of the board, which are the architectural committee, and there's no quorum either. Once all board members have responded to the ARC form, a majority is required to approve the ARC form. Okay, since your ARC is operated by your board, I think all of these need to be done in an open board meeting. Because anytime a quorum of the board is discussing association business, which obviously you need a majority to approve it, this needs to be done in an open meeting. Okay, question 33. If a resident requests to meet with the board in executive session, do you have to comply with this request? I mean, I guess I would say, well, why wouldn't you? Just give them 5 minutes and listen. But if it's like a really difficult person, no, you're not required to do that if you don't want to. But I always like to listen to people. And you don't want them to feel like they're being shut out or, not able to be part of the process. So just some things to think about. I would let them do it. Just put a time limit on it. And you could even set a timer so the person doesn't go too long, and tell them up front, hey, this is 5 minutes. And, we're going to set a timer so that they get whatever they want to say out and you can help them. Okay, that's it for today. We had a great session today. Thank you so much for being here today. This is a busy week for us. We have a lot of different classes we're teaching this week. So today, of course, we had our virtual neighborhood services, HOA Academy. We have 2 more in-person classes this week, one tomorrow in Scottsdale, which I will be teaching in person tomorrow on Wednesday, January 22nd from 1 to 3 at the Mustang Library. We're going to be talking about rentals, ADUs, Corporate Transparency Act again, navigating 2025. So if you're interested in attending, please be sure to register via our website at mulcahylawfirm.com. And then if you're in the Sun City neighborhood, on Thursday at 10 a.m., we are teaching a class for the 2025 Condominium Owners Association annual meeting. And we're also going to be talking about hot topics for Arizona HOAs and condos. And registration is not required, but attendance is limited to members of the Condo Owners Association member associations out in Sun City. If you would like more information on that, go to our website at mulcahylawfirm.com, or please contact the Condo Owners Association of Sun City or visit their website. Okay. Thanks everybody for being here today. Amazing to see all of you. I hope you have a very successful 2025. Please know that we are here to help you in any way as you're navigating your legal problems in 2025. And be sure to continue to come to our seminars. webinars and virtual classes in 2025. We have a lot of really great topics planned. And as always, we answer questions for free at the end of every class. So we will hopefully see you at some of our classes this month. If not, our next virtual class will be our first Fridays, the first Friday in February. So take care, everybody. Have a great week. And thank you for joining us today. Take care. Bye.